It has gravely affected billions, the marginal and underprivileged sections of the society. The present period has raised diverse challenges, socially, economically, culturally, and in the legal sphere. In this session, the presenters will be drawing our attention to a number of such issues to Can you hear me? Am I audible?
Yes, we can see you.
Ms. Hansani received the LLB degree from University of Colombo, Faculty of Law in 2019 and working as an attorney at law. Now I invite Ms. Hansani to do her presentation. Over to you, Ms. Hansani.
Good evening, Honorable Chairs and all. I hope that you all hear me clearly. Let me share my screen. My research topic is environmental damage caused by shipwrecks in Sri Lanka, legal analysis. Introduction to study. Sri Lanka, geographically located at the center of international shipping lanes, has had to frequently deal with shipwrecks. The most recent of such incidents is the grave and irreversible damage caused to the Sri Lankan marine and coastal ecosystems and the animal communities by the Express Pearl ship that recently wrecked in the territorial sea at the country. This research expects to ascertain effectiveness of the domestic laws in Sri Lanka in addressing the impact of shipwrecks on marine biodiversity and its capability and interrelationship with international laws governing the same. The research also intends to identify the loopholes in the domestic law in Sri Lanka and recommend possible remedies to fill those gaps. The research limits only to express pearl ship matter, United Nations Convention of Law of the Sea, MARPOL, and International Convention on Liability and Carriage of Hazardous and Noxious Substances by Sea. And in terms of domestic legal instrument limited to Marine Pollution Prevention Act number 35 of 2008, Coastal Conservation and Coastal Resource Management Act number 57 of 1981, National Environment Act number 47 of 1980. The methodology which is used this research is black letter methodology. The research based on the case laws, International Convention Act as primary sources, journal articles, books, and web articles as secondary sources. Marine Pollution Preventing Act number 35 of 2008 is the currently existing law related to marine pollution in Sri Lanka. There are provisions to control pollution from ship, harbour, ports, and any facilities used by ships to deal with offences, imposing both criminal and civil liabilities for offenders. The Act Section 37 provides for the prevention, reduction, and control of pollution in Sri Lanka waters. The emerging of this act resulted from the signing the United Nations Convention on the Law of the Sea and the International Convention on the Prevention of Pollution from Ships 1973, modified 8 and 1998 by the Sri Lankan government as a sovereign state. Section 26 and 34 provide the criminal and civil liability for those who polluted the ocean. According to the legal provision of the Coastal Conservation and Coastal Resource Management Act, Section 35A, the police officer may, without an order from a magistrate and obtaining a warrant, arrest any person reasonably suspected. According to the Section 35AA of the Act, a person who commits an offence under this Act is guilty of a criminal offence. Part 4B of the National Environment Act discusses environmental quality. Section 23H subsection 1 discusses the pollution of inland waters of Sri Lanka. Section 23H subsection 3 discusses the penalty for pollution of inland waters in Sri Lanka. According to the section, the cost of the harm polluters will get the same fine. Therefore, there is no way to identify the actual cost of harm. Sri Lanka has been ratified and adopted the UNCLOS and MARPOL Convention. According to the UNCLOS, there is the obligation of states to protect and preservation of marine environment. According to the Article 1 of MARPOL, it is clearly stated that parties of the conventions are bound to prevent the marine pollution and act according to the convention in the cases of vessel source marine pollution. Article 235 of UNCLOS mentioned that states are responsible for protecting and preservation of the marine environment. The most recent to the Sri Lankan marine and coastal ecosystem destroyed by the express pearl ship that recently wrecked in the territorial sea of the country. The ship was carrying hazardous chemicals. With the fire of the ship, the release of the chemical was the serious risk to the ocean and the coastal ecosystem. In view of the recent shipwrecks, as the sovereignty state, we have not ratified many of these related international conventions. Especially, I want to highlight International Convention on Liability and Compensation for Damage in connection with the carriage of hazardous and noxious substances by sea. As a state, we had failed to ratify and accede to the Hazardous and Noxious Substances Convention. If the government had done so, we would have been in a better position to claim compensation for the catastrophe created due to express pearl. The International Convention on Liability and Compensation for the Damage in connection with the carriage of hazardous and noxious substances by sea 1992 aims to ensure adequate, prompt, and effective compensation for damage the person and property, cost of cleanup and reinstatement measures, and economic losses resulting from the maritime transport of hazardous and noxious substances such as chemicals. We are a maritime hub. We are way behind in the implementation of international convention and laws. And nextly, I would like to talk about polluter pays principle because I want to highlight one point. It is precaution is worthy than a polluter pays principle. Polluter pays principle spells out the person or the authority who is involved in the polluting the environment should take responsibility for the cost of harm. However, preventing is the best mode to overcome environmental harm near a fine by cover the laws. Consequently, the polluter pays principle needs to connect with the precautionary principle as well. Furthermore, it shows that the first step need to be a precautionary and the second step should be the polluter pays principle. And Bulankulama Vilpattu Chinnakam, those cases have addressed the polluter pays principle. Currently in Sri Lanka, the judiciary has taken certain progressive steps to promote the polluter pays principle. So if we can take a certain progressive step to promote precautionary principle, it will be a great step in our law. My research expect to recommend possible remedies. I would like to recommend establishing a special court for such kind of matters. It is will be very helpful to us. And Sri Lanka has not ratified the most important convention related to the shipwrecks. This failure is a serious weakness in our law. It is the duty of the government to ratify the necessary international convention before the next disaster. Finally, I would like to recommend creating a domestic law that is nourished and is strengthened by international convention. A law must be created that can successfully address any issues that arises. The existing law is positive, but there are places that need to be improved with international convention. We need to fix that. And thank you.
Thank you very much for your presentation. Now I will move to the second presenter. After all the presentations, we can go for the question and answer session. So the second presenter is Ms. Rathnamalala. Her paper title is Will Proceeding Meet Atoms, an analysis of applicability ecofeminism in achieving environmental justice in Sri Lanka. This is a co-authored article by Ms. Rathnamalala and Ms. Wijesooriya. Authors are lecturers in Faculty of Law, General Surgeon Pathology, University of Rathnamalala. They are attorneys at law and currently reading for their MPhil PhD in law. Authors hold LLM and LLB from the Faculty of Law, University of Colombo. Ms. Rathnamalala holds LLM in Human Rights Law, University of Minnesota Law School, USA, and her research areas are human rights law, jurisprudence, and international humanitarian law. Ms. Padmada Wijesooriya holds LLM in Intellectual Property Law, Faculty of Law, University of Exeter, UK. Her research interests are intellectual property law and traditional knowledge. Over to you, Ms. Rathnamalala.
Can you all hear me?
Yes, you can hear you.
Okay. Good afternoon, Honorable Chair, distinguished guests, my dear colleagues, and dear students. Today, my presentation is Will Poseidon Meet Artemis? An analysis of the applicability of ecofeminism in achieving environmental justice in Sri Lanka. Content of the research is as follows: introduction, research objectives, research methodology, discussion and analysis. After that, time to conclude. Research objectives. The main objective of the research is to examine whether there is a link between less participation of women in resolving the contemporary environmental issues and the gross violation on the environmental rights in the Sri Lankan environmental law. Secondary objective is to analyze the paradigms of the above concept theoretically in light of the branches of ecofeminism and applicable environmental law principles. I would like to draw your attention to my research methodology, which I have adopted. This research is basically a legal research, therefore I adopted into legal research methodology. Through this research, I gathered through this research, I gathered journal articles on relevant theoretical framework by authority authors selected based on the purposive sampling of the secondary data on the relationship between environmental law and the feminist legal theory. Historical paradigms on universal gendered aspects on the environmental law. It's a library-based secondary data analysis, recognizing the applicable divisions of feminist legal theory and the principles of the environmental law. Legal research methodology has been adopted to establish the link between the feminist legal theory and the environmental law in order to achieve the environmental justice in Sri Lanka. Framework for the analysis is as follows. Firstly, I am to discuss about the feminist legal theory based on the ecofeminism, and secondly, it is on the environmental law. And based on these two areas, I am to focus on the strengthening the female participation in environmental protection. I would like to draw your attention to certain concepts now in my analysis. Firstly, I would like to draw your attention to the relationship between the environmental law and ecofeminism. historical origins on the close relationship between females and the environment has been considered. For example, if you have heard of this famous lullaby, which I have indicated in the slides, it is a clear indication from the folklore to affirm how much the Sri Lankan women's lives are attached to the forestry and to the nature. The above concept is universally acceptable across cultures, which we accept. At the same time, the inceptors of the contemporary green movements in the world, if we think about it, generally are women. For example, we could get Wangari Maathai, the Nobel Peace Prize winner, and some other examples like Sri Lankan context, like activists like Devan. And in theoretical analysis, I would like to draw your attention to environmental law and the feminist legal theory, the theoretical frameworks. Environmental law looks at all the factors on economy and its production and industry to assess its impact on the environment and propose regulations to reduce environmental harm. Feminist legal theories emphasize the role of law in describing society and in prescribing change, while other types of feminist theory might de-emphasize or even question the role of law in these areas. The most applicable branch of this research is feminist legal theory, is ecofeminism, and its main two divisions, namely radical ecofeminism and socialist ecofeminism. While both approaches reject the domination of those in power over the other, whether the other could be a woman or the nature, they have distinctly different opinions about best approach to take to subvert this power hierarchy and replace it with a new vision of social relationships. And when it comes to social ecofeminism and radical ecofeminism, let's see how these jurisprudential schools of thought could be utilized in protection of environmental law. In framing the analysis, cultural ecofeminists place heavy emphasis on the historical links between women and the nature. On the other hand, in socialist ecofeminism, they link the exploitation of women is similar to that of exploitation of nature. Nature in the sense forest, sea, or animals, so as a result of capitalist economical system. Socialist ecofeminists, therefore, do not link the devaluation of women directly to devaluation of nature. Rather, they see these and other oppressions, such as class and the race, as interlinked parts of the social system, premised on the construing differences as basis for the hierarchical power structure. So, socialist ecofeminists emphasize the fact that as a result of capitalist economic system, both nature and the women are being exploited. That is what socialist ecofeminists and radical ecofeminists jurisprudentially weaving. And let me come to the conclusion based on these theoretical findings. There is a link between environmental law and feminist legal theory, especially in ecofeminism. The very nature of assigned characteristics of women and the nature or the natural environment prone to exploitation, as explained by radical cultural ecofeminism. In capitalism, men are competitive and aggressive in the ground of limited resources. This entails exploitation of resources if there is a need, as explained by socialist ecofeminists. However, the outcome creates a negative impact on humankind regardless of gender. That is the issue. When it comes to the impact, mainly it is regardless of the gender, outcome creates negative impact. And let me come to my recommendations. As the link between feminist legal theory and environmental law have simplified in previous slides, the policymakers should implement the policies on the participation of females in all spheres to join hand the collective efforts to improve the current situation with governmental and non-governmental organizations in Sri Lanka. Secondly, environmental law violations in Sri Lanka occur in many ways. As we know, the gaps in economic policy making, gaps in resource management, and gaps in certain policy implementation in national levels, these lead to another significant gap, that is the lack of principal female policymakers in the process. Therefore, I recommend utilizing the theoretical link, which I have suggested in my research between feminist legal theory and the environmental law to strengthen the female participation in Sri Lankan environmental protection will be a tool to overcome certain challenges. With this, I'm to conclude my session I believe that environmental justice could be achieved through gender equality. As indicated in the slides, Artemis is the Greek goddess on nature and the feminine nature. Poseidon, on the other hand, the Greek god on the aggressive masculinity. Therefore, I believe, as I indicated in this presentation, Poseidon should meet Artemis to overcome these challenges through achieving gender equality in environmental protection. At the same time, I would like to I take this opportunity to acknowledge all the lecturers in the Faculty of Law, KDU, led by Ms. Asanka Edirisinghe and the administration for initiating the green movement in our prestigious university. Thank you very much.
Thank you, Ms. Rathnamalala. Very interesting title and presentation. Now I move on straight away to the next presenter. The next presenter is Ms. Edirisinghe. She will be discussing about for reincarnation and analysis of the application of the polluter-based principles for environmental restoration in Sri Lanka. This is also co-authored article. Ms. Mudalige and Ms. Edirisinghe are the co-author. They are senior lecturers at the Faculty of Law, John Kotalala Defense University, who passionately believe that the environment belongs to all the living beings. Now I invite Ms. Edirisinghe to start the presentation. Please start your presentation.
A very good afternoon, ladies and gentlemen. The title of my presentation is For Reincarnation, an analysis of the application of the polluter-based principle for environmental restoration in Sri Lanka. This presentation is based on a co-authored paper by Ms. NKK Mudalige and myself bearing the same name. First of all, I will give you a brief introduction to our research. In May 2021, the Singaporean container ship MV Express Pearl en route from India to Singapore caught fire and drowned in the sea around 9.5 nautical miles northwest of Colombo. And the ship drowned with 1,486 containers containing tons of hazardous and highly reactive chemicals, 78 metric tons of plastic needles, and 325 metric tons of bunker oil aboard. This incident created an unprecedented and an unimaginable environmental disaster with widespread spillover effects on the marine environment, marine species, and marine resources. While some of these environmental damages could never be rectified, the most viable solution available to preserve the pollution-ravaged oceans in Sri Lanka is making the polluter to restore the environment into its previous condition, at least to the most part possible. So the research problem which was sought to be addressed in our research is whether the polluter-based principle as recognized and applied in Sri Lanka can be used to impose a duty on the polluter for ocean environment restoration in the MV Express Pearl disaster. The methodology used in the research is the black letter approach of research or the doctrinal research methodology based on primary and secondary sources. Now I will move on towards our discussion and analysis part. The polluter pays principle embodies the simple idea that he who pollutes the environment shall bear the cost of such pollution. The polluter pays principle was recognized for the first time in a council recommendation on guiding principles concerning the international economic aspects of environmental policies of the OECD in the year 1972. Then it was recognized in very clear and cogent terms in two of the landmark environmental legal instruments in the international arena, the Stockholm Declaration in 1972 and the Rio Declaration in 1992. Today, the polluter pays principle is recognized in a large number of international environmental legal instruments, and also the principle now forms an integral part of the domestic legal systems of many countries around the world. When looking at the scope of the polluter pays principle in order to be meaningful shall impose the duty of bearing the total cost of pollution on the polluter. So what is meant by the total cost of pollution is a salient question we shall give an answer to. In an extremely anthropocentric view, the total cost of pollution may mean compensating the people who have gotten affected by the pollution or the human victims of pollution. However, at this point, we shall bear in mind that the human beings are only a part of the wider earth community, and human beings are not and cannot be the sole victims of environmental pollution. Environmental pollution, of course, affects the human beings, but similarly, it affects the environment and all its components, living and non-living both. Therefore, the true application of the polluter pays principle and the most accurate interpretation to polluter pays principle shall entail two things. The first one is compensate the victims who are victimized by pollution. Secondly, and more significantly, to restore the environment back into its previous condition. This second element we shall bear in mind is more complex, more comprehensive, and even more and can even be more expensive. Now, the duty of the polluter to restore the environment is being increasingly recognized in the international arena and in different jurisdictions around the world. In Costa Rica versus Nicaragua, decided in 2018, International Court of Justice clearly recognized that the polluter pays principle contains the duty of the polluter to restore the environment into its previous condition. Environmental restoration is recognized as an integral part of the polluter pays principle in the Indian jurisdiction, particularly through three landmark cases: Well-Lord Citizens Welfare Forum versus Union of India, Indian Council for Environmental Action versus Union of India, or the sludge case, and the MC Mehta versus Kamalnath case. By virtue of these three cases, environmental restoration is now recognized as a salient feature of the polluter pays principle conclusively and comprehensively in the Indian jurisdiction. When it comes to the Sri Lankan situation, before moving on, we shall bear two things in mind. The first one is the polluter pays principle is recognized mostly through judicial activism or through the judiciary rather than by the legislature in Sri Lanka. Secondly, environmental restoration was not recognized in the Sri Lankan context until the Court of Appeal delivered the Vilpattu judgment in November 2020. The first case which recognized polluter pays principle as a part of the domestic legal regime in Sri Lanka is the landmark Tikiribanda Bulankulama versus Secretary Ministry of Industrial Development and others, or which is commonly known as Ippavala case. In this case, Honorable Justice Edirisinghe recognized the polluter pays principle as a part of the domestic law in Sri Lanka and held that the cost of environmental damages should be borne by the party who causes the environmental damage in order to mitigate the environmentally degrading effects of a project. In this judgment, His Lordship nowhere mentions expressly the word restoration of the environment. However, His Lordship signaled that environmental restoration duty to restore the environment shall be imposed on the polluter in order for the polluter pays principle to be meaningful. Secondly, in Ravindra Gunawardena Kariyavasam versus Central Environmental Authority, which is commonly known as Chunnakam case, the Supreme Court of Sri Lanka directed the respondent company, Northern Power Company Private Limited, to pay compensation in a sum of 20 million rupees to the residents of the area who were gotten affected by the groundwater pollution which occurred due to the operation of a thermal power station by the respondent company. This judgment raises two questions. The first one, why did not the Supreme Court impose the entire cost of pollution on the respondent? If you refer to the judgment, you will clearly see that His Lordship says that at least a part of the substantial loss shall be borne by the polluter. So it is questionable why the entire cost was not imposed on the polluter. However, that too can be justified by referring to the judgment, because in the judgment, His Lordship recognizes that the Northern Power Company Limited is not the sole perpetrator of the groundwater and soil pollution in the area. Secondly, whether the court has been entirely successful in imposing the liability of environmental restoration on the polluter. In this case, the focus of the court was on clearing or cleaning the contaminated wells rather than the restoration of the groundwater, polluted groundwater in the Chunnakam area. Therefore, it is questionable whether the environmental restoration is truly recognized in the Chunnakam power plant case. Then the third case, Center for Environmental Justice Guarantee Limited versus Anura Edirisinghe and others, the celebrated Wilpattu case decided in the year 2020, the polluter pays principle was interpreted by the Supreme Court, by the Court of Appeal in Sri Lanka, following the Indian approach to mean the absolute liability for the harm occurred to the victims as well as to the environment. So in this case, the polluter pays principle was interpreted to mean two things: the duty of the polluter to compensate the victims of pollution. Secondly, the duty of the polluter to restore the environment into its previous condition. This is the first case ever in the history of Sri Lanka which recognizes in clear and cogent terms the duty of the polluter to restore the environment into its previous condition. In this judgment, the court dealt with an alleged illegal settlement of internally displaced persons in a forest complex adjoining the Wilpattu National Park, and in the case, the Court of Appeal issued a writ of mandamus ordering the Conservator General of the Department of Forest Conservation to implement a tree planting program in any area equivalent to the reserve forest area used for resettlement of the internally displaced persons. This judgment is also a bit questionable because it is not clear whether a tree planting program in any area equivalent to the deforested forest area can be taken as a true restoration of the invaluable forest resource. Because when it comes to a forest, it's not just the trees, it is a system containing the trees, animals, insects, birds, soil, and all these things are lost because of the illegal settlement of the internally displaced persons. And a tree planting program in an area equivalent to the lost area will not be a true restoration, but still the judgment of Honorable Justice Janagri Silva shall be highly appreciated because it is a significant landmark in the environmental jurisprudence in the country for its recognition of the duty of the polluter to restore the environment back to its previous condition in clear and cogent terms. Then, when applying the polluter pays principle and the restoration of the environment into the MV Express Pearl disaster, a fundamental rights petition has already been filed in the Apex Court of Sri Lanka by the Centre for Environmental Justice Guarantee Limited and several other petitioners against the Marine Environmental Authority and several other respondents for their failure to take measures to stop the marine environmental pollution due to MV Express Pearl disaster. So the researchers recommend that the polluter pays principle shall be strongly recognized in this case, reaffirming the duty of the polluter to restore the marine environment into its previous condition in clear and cogent terms. When this restoration of the duty of the polluter to restore the environment into its previous condition is laid down clearly by the Apex Court of Sri Lanka, no authority would be able to question this duty of the polluter to restore the environment. Then in conclusion, the MV Express Pearl disaster has been one of the greatest environmental tragedies in the recorded history of Sri Lanka. While the line of incidents which ultimately resulted in this massive environmental disaster cannot be reversed, certain damages caused to the environment as a result of it can still be and shall be reversed. In Sri Lanka, the polluter's duty to restore the environment is now recognized basically by virtue of the Wilpattu judgment. It would therefore not be unreasonable to expect the judiciary in Sri Lanka to once again play its crucial role in the fight for environmental protection in the country by the imposition of the duty on the polluter to restore the environment in the MV Express Pearl disaster and to restore the environment from the unprecedented and far-reaching damage caused by this massive disaster. With that, I finish our presentation. Thank you very much.
Thank you very much, Ms. Edirisinghe, for your nice presentation. It's very impressive. Now, let's move to the next presenter. The next presenter is Ms. Walgama. The presentation is about striking in balance between COVID-19 regulatory responses and the fundamental rights of citizens in Sri Lanka within the new normal. She has completed her LLB at General Surgeon Putalawala Defence University. She takes a keen interest in the areas of constitutional law, international law, and administrative law. This research deals with the legality of the imposition of the COVID-19 regulatory responses and the needs of strict adherence to the rule of law to ensure the protection of rights of the citizen. Over to you, Ms. Walgama. Please, Ms. Walgama.
Thank you. Good evening. Am I visible? Audible?
Yes, you're audible.
Yes. Okay. Good evening, the academic staff of Faculty of Law, KDU, erudite scholars, colleagues, and distinguished guests. First of all, I'd like to take a moment to thank KDU for giving me this opportunity to present my paper at the 14th International Research Conference. So going on with the general theme of the IRC for 2021, I have conducted my research on the topic striking a balance between COVID-19 regulatory responses and the fundamental rights of citizens in Sri Lanka within the new normal. To provide you an overview of my presentation, I will be basically providing you an introduction into my research area. Thereon, I'll be discussing the main research problem that I've sought to address through the research. the main objectives and the methodology are adapted in concluding the research, and thereon the analysis into the research, and I will be arriving at conclusions. So with the World Health Organization declaring the COVID-19 a global pandemic, states have been compelled to impose various restrictions to curb the virus. So in crisis response, Sri Lanka too has implemented certain restrictions with the intention of limiting the spread of the virus. However, with the imposition of most stringent restrictions, the fundamental rights of the citizens have been questioned, and the general public has raised concerns that these restrictions have imposed breaches on their fundamental rights violations. However, counter-arguments suggest that these should not be viewed as unlawful restrictions because they have been imposed following the rules and regulations, basically the laws that are already in a time of pandemic. However, it should be noted that the restrictions should be imposed in a lawful manner to ensure the rule of law of the country. When talking about the research problem, based on the situation, it is clear that the basic research problem is that the imposition of these restrictions have created a breach of the fundamental rights of the citizens according to the opinion of the general public, and in this research, the impact of such restrictions on the fundamental rights will be evaluated along with how they impose challenges on the rule of law and democracy in a broader sense. In this case, the basic research objectives which are sought to address is to recognize the various types of restrictions imposed in response to the crisis, to analyze what fundamental rights have been breached through these restrictions, to identify the impact of these restrictions on the fundamental rights of the citizens, and to assess the role of rule of law in safeguarding the fundamental rights of the citizens. There, I have basically adapted library research through adoption of the black letter approach, where I've used primary sources such as statutes and regulations, regulations, and secondary sources such as scholarly articles, working papers, and reviewed reports of the United Nations. I'm sorry, if can you please tell me if you can see my presentation?
Yes, it's visible.
Okay,
Yes.
okay, thank you. Then on, moving on to the the importance of fundamental rights in the pandemic, it is important that the country takes a multi-stakeholder approach to the virus through extraordinary measures. However, with the imposition of more stringent barriers, the fundamental rights of the citizens have been breached, and the general public has raised issues as such. It is noted that through the Constitution, limitations on fundamental rights are permitted, but on the other hand, these unprecedented times do not provide government an arbitrary authority to impose whatever the regulations they think as necessary, imposing challenges upon rule of law and democracy. So moving on with the particular violations or the particular rights that have been violated, the freedom of movement guaranteed by Article 14(1)(h) of the Constitution has been breached with the imposition of the travel restrictions. As I said earlier, restrictions can be imposed, but they should be proportionate to achieve the legitimate aim. Also, it is noted that people who have breached these restrictions have been arrested and detained. The arrest and the detention of the people who breach these restrictions should be conducted in a lawful manner according to the criminal procedure of the country. With respect to the breaches of equality, it is obvious that the main right that is violated through this through the imposition of restrictions is the right to equality. People have been denied of access to medical services, medical information, and in the same sense, children have been denied of their opportunities to learn because of the adoption of distance learning techniques and the inability for them to access those tools. In the same sense, freedom from torture and degrading treatment as provided for in the Article 11 of the Constitution, which embeds the two concepts of dignity to human life and implied right to life, has been breached to a certain extent with the imposition of the restrictions. It should be noted that everyone who has been infected with the COVID-19 virus should have access to medical service and cure themselves from the disease. In the same sense, as I said earlier, the arrests and detention should be carried out with dignity to human life. Detaching from a fundamental rights perspective, with the increased cases of domestic violence, there is a significant threat imposed on the lives of women and children, more specifically. So it should be noted that the government should, to a certain extent, impose various measures to limit the occurrences of domestic violence. Thus, it is clear that by ensuring the fundamental rights of the citizens, rule of law can be established. Rule of law basically states that every person should be equal before the law and should be subject to the due process of the law. In that sense, the government should not engage in arbitrary policy making, and the restrictions they impose should not be driven politically. They should be proportionate, flexible, and legitimate to achieve the aim of curbing the virus. In this way, the rule of law can be established by giving due recognition to the dignity in a democratic society. So based on these research data, it can be concluded that fighting against the COVID-19 virus requires a collective action, and the sole responsibility of curbing the virus cannot be held only upon the government. It becomes the responsibility of the citizens to ensure that they adhere to the restrictions imposed by the state, and the government should, in the same sense, should be accountable for the actions and the policies they introduce. Thus, fighting the pandemic or overcoming the COVID-19 pandemic is basically an integrated and inclusive approach, which is to be supported by the general public and the state in equal sense. In this manner, the arbitrariness of the government and the fundamental rights of the citizens can be protected, whereby a rule of law will be established and Sri Lanka would be able to establish its long-standing principles of democracy. So with that, I reached the end of my presentation. Hope I made enough justification into my research area. Thank you for your attention.
Thank you very much, Ms. Walgama. It's very nice presentation, and I think in the question and answer session there will be more discussions here regarding this title. Now let's move to the last presenter. The last presenter is Ms. Supunika. The paper title is Apps-Driven Uncertainty of Welfare of Gig Workers. This is also a co-authored article by Ms. Supunika and Ms. Liyanage. Ms. Supunika is a LLB graduate of General Sir John Kotalala Defence University. She is a final year student of Sri Lanka Law College. Her research interest includes criminal law and intellectual property law. Ms. Liyanage is a LLB graduate of General Sir John Kotalala Defence University. She is also a final year student of Sri Lanka Law College. Her research interest includes environmental law, criminal law, and constitutional law. Over to you, Ms. Supunika.
Thank you, madam. Thank you, madam. Honorable Chair, ladies and gentlemen, our research topic is app-driven uncertainty of welfare of gig workers. The emergence of global pandemic affect loss of present and future employment opportunities due to the immediate aftermath of curfew and lockdown.
This has created a demand for some opportunities through the gig economy, specifically the app-based gig work. But app-based gig workers have no safeguard from labor legislations because of their uncertain employment status. So the aim of this research is whether the welfare of gig workers can be protected under the domestic labor legislation in Sri Lanka. And our objectives are to discuss whether app-based gig workers can be classified as contract of service or contract for service. And we examine it by comparing the position of UK, USA, Canada, and to propose recommendation to uphold their welfare. In here, we use black letter and comparative research methodology to conduct this research. When we move to results and discussion, traditionally, nature of the employment can be classified as contract for service and contract of service. Contract of employment is contract created between employer and employee. And contract for service means an independent contractor who is contracted to perform a service to another business as an employee and has direction over the work to be done, and the employer does not have. In the modern labor market, remuneration of gig workers who are based on the app are paid by such platforms. But the problem is, most of the time, such workers are considered to be independent contractors regardless of whether apps unilaterally control their choice of work and the payment rates. Such control of autonomy by the apps and the lack of transparency between clients and the gig workers are creating confusion about the status of employment as to whether they can be considered as independent contractors. Since they are considered to be independent contractors, they are not covered under the labor legislations, and it leads to labor exploitation in new normal, because they have to carry out their work in unsafe environment and their labor rights are not protected as human beings, which are recognized under Article 23 of UDHR and Article 7 of ICESCR. These rights can include the right to free choice of employment, protection against unemployment, etc. Apart from this, International Labour Organization recognizes fundamental principles and right at work, which includes elimination of forced labor, elimination of discrimination regarding employment to ensure decent work, equity to achieve welfare of workers, and economic growth. As a welfare state, Sri Lanka has an obligation to ensure social security and welfare of the people by protecting social order under Article 27 of 1978 Constitution. But many labor legislation include the Industrial Dispute Act define workmen, but they cover only contract of employment within the meaning of traditional employer and employee relationship. They do not cover the app-based gig workers, even though Article 14G of the Constitution grants every citizen the right to engage in lawful occupation. Also, there is a necessity to give the same right for app-based gig workers under Article 12, which means the equal remuneration and some extent of equal protection should be granted for them irrespective of the mode of the platform. So, according to our findings, in UK also, the definition of workman in Labour Statute do not cover the app-based gig workers, same as the Sri Lanka. However, in the case of Uber BV and others versus Aslam and others, the right of such workers were awarded the same status as right of the employers. Here, the main issue was whether drivers of private hire vehicles who provide service to the app, Uber app, can be considered as employees. Then the Supreme Court confirmed that reality of the relationship of the parties to agreement must be determined by the examining all the circumstances, not relying only upon the written documentation as held in the case of Autocolors Limited versus Belch. And the court applied the integration test and the economic reality test. But at the end, court analyzed the facts and circumstances of the case by applying the control test and decided the Uber drivers should be considered as not the self-employed, but as workers who should be entitled to minimum wage, paid holidays based on the 5 components. They are, first one is Uber sets the terms and condition of its service. Secondly, Uber has significant control over the manner in which Uber drivers should be worked. Since they have a rating system, if the Uber driver fails to complete the daily targets, they have to either pay penalty or terminate the contract. Thirdly, Uber has taken a step to ensure that drivers and passengers do not enter into agreement outside Uber. Fourthly, Uber sets fares for each ride, not allowing the drivers to set their own price. And fifthly, drivers face penalties for cancelling and not accepting the rides. When it's come to the Canadian jurisdiction, they rely upon the agreement between parties without considering the employment status of app-based gig workers. So in the case of Uber Technologies versus Heller, question arises that whether such workers can be categorized as employees who are entitled to the minimum wage with vacation pay and the overtime under Ontario Employment Standard Act 2000. For that, the court only examined the inequality of bargaining power and improvident bargaining as two-part test to determine whether an agreement between app-based gig workers and such gig company is unconscionable. And at the end, they concluded that agreement was invalid and unconscionable. When it's come to California situation, in the case of Dynamic Operation West versus Superior Court, adopted the ABC test to determine employment status of such workers. According to that test, employer needs to prove that, firstly, individuals are free from control and direction of the employer relating to the performance of service. Secondly, service is performed outside the usual course of business of employer. And thirdly, individuals are customarily engaged in independently established trade, occupation, profession, or business to satisfy the court whether such worker is independent contractor. However, in this jurisdiction, we can see that they do not only use judicial activism, but also take steps to address the issues through codifying bill and policy. So the state of California passed California Assembly Bill 5 to create some extent of clear classification for app-based gig workers as employees instead of independent contractors, to halt against the deprivation of basic labor rights by apps 22, clarify the status of app-based drivers as independent contractors by granting the certain benefit and develop policies against workplace discrimination and sexual harassment for their app drivers through it. So it seems that there is no standards of practice to define app-based gig workers, but according to the new normal, there is a prompt need to identify the employment status of app-based gig workers domestically because the end of the pandemic is unpredictable. As a result, app-based platforms have created jobs for gig workers to cater to this situation, and it is evident that the exploitation of rights of the gig workers have become inevitable. So we would like to recommend that a regulatory framework should be established where labor legislations cover independent contractors to facilitate welfare and working condition of workers, and it should be created in manner which ensure the fundamental right to lawful occupation. Also, a clear, defined and unambiguous definition for the term independent contractor should be incorporated to the existing labor legislation. Also, it could be recommended that separate ad hoc tribunal be established to ensure the right to fair hearing and uphold the principle of natural justice. At present, aggrieved parties can only seek remedy for a breach of contract from the district court because independent contractors are not recognized under the labor legislation, hence are not entitled to get a just and equitable award from labor tribunal because they are not protected under the labor legislation. In addition to it, it is better to establish mediation board to review the contract of app-based gig workers since most of them are unskilled workers. Well, we would like to emphasize that in Sri Lanka, only individuals who are subject to the contract of employment are subject to under the labor legislations. However, they do not provide protection to app-based gig workers. Therefore, it has led to exploitation of human rights of app-based gig workers in new normal. Hence, there is a prompt need to recognize the right of the gig workers. So at least to provide them with minimum wage benefit and health and safety benefit in new normal with considering them as employees, not independent contractors. Thank you.
Thank you, Ms. Supunika. Very interesting and impressive presentation. Now the audience is open for question and answer session. Please raise your questions.
Hello, I'm Mudalige. I have a question to Supunika.
Yes.
You mentioned that FR provisions of the Constitution of Sri Lanka regarding employment rights and said that gig workers are not included in your analysis. However, there are procedural constraints, as you know that since only the violations of FR by administrative or executive action can be remedied through our present constitution. So, how do you suggest to remedy the violations done by the private sector? Whether it can be employees or otherwise. These gig works, how do you justify it?
In here, hello.
Yes, we can hear you.
In here, we only consider the average gig workers, not the all gig workers, all types of gig workers.
So their employment rights can be violated by private sector, isn't it?
Yes.
So I'm asking your justification towards the application of FR, since you said it in the analysis. Any comments regarding that?
In our presentation, we only consider the private sector, not addressing the government sector in here.
Yes, that is why my question is, you said that in the you said it can be applied the fundamental rights and to that. So there's a procedural constraint to not to apply the violations done by the private sector employees through FR. We can't remedy that. Any justification or recommendation to the law?
I think we have to think about it according to our research.
Thank you very much for the comment.
Welcome.
I'm Edirisinghe. I have a question for Ms. Tamasha Walgama. Ms. Tamasha, the World Health Organization has recommended that the best way to fight the COVID-19 virus is vaccination. However, it is not completely proven that the vaccine is entirely safe and the long-term effects are unknown. In this situation, is it in line with protecting human rights if the vaccine is made mandatory, or will it be a violation?
Well, it's like this now. The suitability of the vaccine for to be injected to people is basically a medical concern. So now, if it's like for it to be a human right violation, the medical authorities should be using the vaccine as a mechanism to, like, not with the aim to protect humans, but when it comes to the COVID-19 virus and the vaccination, irrespective of its type, all the vaccines are proven to protect human lives. So in that case, I think there is a certain sense of protection of human rights in respect to the fact that they will be protected from the disease to a certain extent, at least. So the suitability of the vaccine and the after effects are basically, according to my point, is a medical concern. And I do not think that it would be a human rights violation that the after effects and the diseases a person is prone to because of taking the virus would be a human rights violation. Yeah.
Thank you, Ms. Tamasha.
Thank you.
Any other question?
I'm Dr. Rodrigo. More than a question, I have a general comment to make about the first three papers, with which I was very pleased. I was very impressed with the first three papers. which dealt with various aspects of environmental pollution. Now, almost all three papers dealt with, more or less, dealt with the polluter pays principle, with which I am not very happy, because unlike in private branches of law, like law of contract and dealing, compensation will not be an adequate remedy, for the reason that, you will, in certain damages to environment, that cannot be restored at all. Now think of damage to the ozone layer and the damage to the forest cover in a country. That takes, a long time. So I think it is almost, it is impossible to restore to the original position. So therefore, we as lawyers owe duty to discourage or to minimize the damage to environmental pollution, particularly like the damage to ozone layer, then forestry, things like that. So this is not really a question, but a general comment. Thank you very much.
That is a comment more than a question. So if you are willing to add something, please. Ms. Hansani, do you like to add something?
No, ma'am.
Then Ms. Edirisinghe, would you like to add something?
No, I don't like to add, but I would like to thank Dr. Rodrigo for that comment. Thank you very much, sir.
Any other questions? Okay, I have a small question from Ms. Hansani. You suggest one court. What recommendation was a court? Did you suggest an international court or domestic court? What kind of court? Is it like ICJ or ICC?
I mean, ma'am, domestic court, because in Sri Lanka there is many cases in the court, fundamental cases, criminal cases, civil cases, all are in our domestic courts. But this environmental damages in my paper, I limited to the express shipwreck and threat of the environmental damage. So I wanted to explain. I would like to recommend a very special code for the environmental damages, because court decisions and court proceedings are will be late. So that kind of irreversible damages can be harm to our environment. So that's only I recommend the special court complex for this kind of cases.
A special court or a tribunal or both?
I think special court is enough.
All right. Then can't we go for an arbitration process? You're not suggesting that?
Yes, ma'am. I think special court is enough, because my target is avoid delays. So I think special court is enough.
Right. I have another question. That is to Ms. Walgama.
Yes, ma'am.
I couldn't understand your recommendation, are you suggesting any recommendations to the administrative administration process, or what was the recommendation? That is very vague.
Yeah.
So can't you give some precise?
Yeah, basically what I meant to say was that the government should not engage in arbitrary decision making. Like as I said in my paper and my presentation, the responses, the regulatory responses should be legitimate. Particularly in the arrest and detention, we have seen the people who have breached those restrictions being arrested in unlawful manners, against the Criminal Procedure Code. So it is basically actions like that that should be avoided. I do not suggest that the imposition of regulatory responses should be avoided, but they should be avoided in they should be imposed in a legal manner, so that it does not interfere with the fundamental rights of the people. And also the imposition.
That means we need to take any administrative action or the legislative actions. What kind of actions?
Legislative action is enough. What I basically wanted to point out was
you're suggesting some enactments.
Not necessarily. What I basically suggest is adherence to the existing laws. Like in the example I provided, like the Criminal Procedure Code says that there should be a minimum use of force and there is a manner in which the arrest should be conducted. But if there is the use of force than the extent necessary, that can be a breach of fundamental rights of the citizens. So it is that I suggest which should be avoided, and the COVID-19 virus and the ability to make such restrictions should not be a point where the regulatory authorities and the people who are responsible are making arbitrary decisions. So I don't necessarily suggest that there should be amendments to laws or any procedural change as such, but I mean that there should be a strict adherence to the laws that are already in place. Yeah, that's it.
But anyway, in a pandemic situation, we need to restrict some laws. So how we can balance that? So anyway, we have to.
Yeah, and restrictions are permitted in the Constitution, yes. Now, when we take the Constitution, it says that the restrictions, Article 15, the restrictions should be imposed according to the law. Now, if I take the example I said, there should be a minimum use of force. If we look back into how the arrests have been carried out, there is a certain gap between the practice of the law and what is actually stated in the law. So it is that I say would to a certain extent be a breach of the fundamental rights, but again it should be considered that fundamental restrictions on fundamental rights are necessary, and during this time it is necessary that the state takes such actions to protect the virus, because at the end of the day it will again be for the benefit of the people. So there should be a balance of how the government is taking actions to protect the rights of the citizens while ensuring that there is a limitation on the spread of the virus. So yeah.
That means you are saying the practical issues are there, not the laws.
There are practical issues, yeah.
Law is fine. The problem is practically.
Practice, yeah. Mostly it is, yeah. Because when we take the legal framework, there are quarantine measures can be imposed according to the acts and other regulations. Fundamental rights can be restricted. Arrests can take place. Everything, the law is specific and it has stated how these arrests should be there, everything, and how restrictions has to be imposed. But it's in practice that there is a tendency for regulatory authorities to maybe overuse the power vested on them and acting in an arbitrary manner just for the sake of curbing the virus. So what I basically suggested is that the arbitrary aspect of the regulatory authorities should be restricted so that it does not create a restriction upon the fundamentals.
How to restrict it? That means with using courts, when we go to the courts, how court should interpret like that you are in suggestion, or what kind of suggestions you are
if there is
suggesting?
a fundamental rights violation and a person thinks that okay, his rights have been violated, he can obviously go to courts, because if we say in an arrest where the police has arbitrarily used power, they can go to courts. So that court procedure is also there. So it's basically, like I pointed out, it is the use of arbitrariness that should be protected. Basically, the regulatory authorities and the people in equal sense should respect rule of law. Thank you.
Audience, are there any questions?
Madam, I am Edirisinghe again. I would like to firstly wish Madam Miss Asanka Edirisinghe for the presentation. It was such a nice presentation. And I have a question to ask from her. Madam, do you believe whether polluter pays principle has been accepted as a customary international law in environmental law?
Well, we cannot give an exact answer to that. There are certain judgments which interprets the polluter pays principle to mean a customary international law principle. And it is embodied in a number of key international instruments like the Rio Declaration, Stockholm Declaration. So of course, yes, some authors, they argue that it has attained the status of a customary international law principle, but this academic debate still goes on. It's not settled yet. So perhaps with time, yes, of course, it will turn out to be a customary international law principle. And if it is true, it is like one of the most major achievement that can be achieved by the environmental movement, I believe.
Thank you, Madam.
Any other question from the audience?
Yes, I have a question for Ms. Hansani about shipwrecks. I just want to know whether we have a strong legal framework to fight any similar future problems, or do we already have the laws and we need implementation?
We have Can you hear me?
Yes, we can hear you. Please ask.
We have MIPA Act. MIPA Act is a very powerful act. Sometimes MIPA Act has covered the coastal conservation also. So MIPA Act is a very powerful act. But I think the main weakness in our law is we are not ratified some special convention, international convention. If we can ratify it and adopt that convention, our law will be very powerful than in this situation. According to my research, I recommend to ratify and adopt the HNS convention.
Ms. Hansani, are there any special provisions in the conventions you are emphasizing?
Sorry, I didn't hear clearly.
Ms. Hansani,
yes.
Are there any special provisions in the conventions you want to emphasize?
You mean HNS convention?
Yes. Or is it proper to adopt the convention as entirety?
Can you hear me clearly?
Yes, we can hear you.
Actually, the hazardous and noxious substances by sea International Convention of HNS aims to ensure adequate, prompt and effective compensation for damage to person and property and cost of cleanup and reinstatement measures and economic losses resulting from the maritime transport of hazardous and noxious substances such as chemicals. So I want to highlight that points when I discuss the research paper. I wanted to highlight that point only.
Any other question?
There is no question, but let me add something to that question and the answer from a practical perspective. Being a person who had been involved in the amendment of the Marine Pollution Prevention Act number 35 of 2008 in 3 consecutive occasions, that is in 2014, 2018, and lastly in the 2021, we had consistently made the appeal to the government that this whole convention be applied and incorporated into the Marine Pollution Prevention Act as it is possible, or to bring another law accede and accept the provisions of the convention so that we could adequately get compensation from a maritime disaster. Well before this Express Pearl disaster occurred, this suggestion was first mooted in 2014 and once again in 2018, and now this time in 2021, everyone is, I think, accepting the notion, but those days it was not regarded duly and we are still facing the consequences of that. Just an addition to the comment made by Ms. Hansani.
Right, thank you very much, sir. And so we had a great evening full of speech. And I request all of you to read the full papers of the presentations and enhance your knowledge of these areas and engage in furthering these discourses. So now we have to finally wrap up the session. I thank all 5 speakers, the rapporteur, for conducting this session. Thank you very much and good evening to you all. Stay safe. You're muted.
The Faculty of Law has selected 5 researchers for poster presentations, and they were evaluated by a panel comprising of His Lordship, the Chief Justice, Jayanta Wijesooriya, President Council, Ms. Kalyani Jayasekara, Head, Department of Civil Law, Faculty of Law, KDU, Major Shiran Mendes, Head, Department of Military Law, Faculty of Law, KDU. The panel has selected 1 poster presentation as the best poster presentation, and the best poster presentation award goes to AP Liyanage. Thank you. And now the time has come to announce the best paper presentation. Papers presented in the technical sessions in law in the 14th International Research Conference of KDU were evaluated by a panel comprising of Dr. Dante Rodrigo, President's Counsel, former Principal of Sri Lanka Law College, Mr. Mahesh Abenayaka, Senior Lecturer, University of Murtua and Visiting Lecturer, Faculty of Law, KDU, Mr. Rajiv Amrasuriya, Attorney at Law, Secretary, Bar Association of Sri Lanka. The panel has selected 1 paper presentation as the best paper presentation, and the best paper presentation award goes to KAAN Tilakaratna and HSV Mendes. Thank you so very much, ladies and gentlemen. Congratulations goes out to all the award recipients this evening, and a very special note of our gratitude must go out to our distinguished panel of judges of both the poster and paper presentations for their immense contribution. And thus, in conclusion, on behalf of the organizing committee, I would like to thank Ms. Kalyani Jayasekara for chairing this session. Ladies and gentlemen, with that, as we formally conclude the final session, please rise for the national anthem.